This is video lecture number 2, covering that writings chapter in the book. So we're picking up here with lecture 2 with the People versus NSCAT case on page 671. So remember, the defendant here was charged with obscenity, with exhibiting an obscene film. So what happened here is apparently the police had gone undercover into his theater or his place of business and had seen the film, and the prosecutor at trial had offered just oral testimony by the police about what they had seen when they watched the film. And the appellate court here held that it was reversible error that the trial court had allowed that oral testimony by the police because, in fact, the best evidence rule applied here, and the prosecution didn't supply an original of the film, a copy of the film, or most importantly, give any kind of excuse for not producing the film. And the appellate court here said the same also applied to the photographs that the police took of the film, just the still photographs that the court had also admitted. So NSCAT was a California case back in 1971, but I want to talk about, well, what if this case had been decided under the current federal rules? The first thing we'd want to do, of course, is to talk about the fact that the federal best evidence rule does cover films. Rule 1001C that I refer to on the slide here defines photograph that is used in the rule as defines it very broadly, right, to include any photographic image or its equivalent stored in any form whatsoever. So that clearly would cover films. So we know the prosecutor in NSCAT didn't produce the original of the film. And looking at Rule 1004 to see, well, what excuse might have been offered. Let's say the prosecutor didn't have the original. We know that if there's an excuse offered, that sometimes testimony in lieu of a copy or the original of the film might be acceptable. So looking at Rule 1004, I zeroed in on 1004C, that exception for originals that are in the possession of your opponent. And you actually saw in this case on page 672 that the appellate court apparently also discussed that under the rules as they stood in California back in 1971. But apparently in this case, the prosecutor didn't make any showing that the film was still in the hands of the defendant here. The defendant, of course, if we were looking at the current federal rule, the defendant would have obviously been put on notice by the complaint in the case, the indictment, would have been put on notice that the original would be a subject of proof at the trial or hearing, as the rule requires. So in fact, if the prosecutor could have made a showing that the defendant still had the film and didn't produce it, then the oral testimony would presumably maybe have been allowed back then, and certainly would presumably be allowed today under the federal rules. All right, but that was not the case here, so it was error to allow testimony about the film by the officers. The other thing that I reference on the bottom of this slide is this question. What about the photos that were taken of the film? Would they be allowed in under the federal rules? And so the question is, are these photos duplicates within the meaning of Federal Rule 1003? And the only real answer to that question is that photographs showing individual still shots of a film should not be considered duplicates of the film. Now, the NSCAT case was 1971. I have on this slide the Miller test for obscenity. That's a First Amendment issue that also might be on the bar. The test for obscenity. We see this coming out of the Miller case in 1973. So even though that case was 2 years after the NSCAT case, prior to the Miller versus California Supreme Court case, of course, very similar definitions of obscenity were sort of in existence in the various jurisdictions. So going over the Miller test, basically the definition of obscenity is whether the average person applying contemporary community standards would find that the work taken as a whole appeals to the prurient interest, whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law, and whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. So in this instance, in the NSCAT case, which was an obscenity prosecution, the trier of fact really had to determine whether the work taken as a whole appeals to the prurient interest and so forth under the Miller obscenity test, and even in 1971 under a very similar test that would have been used. So it would clearly not be fair to just admit still photos of a film because the redeeming social value issue or whether the film appeals to the prurient interest, those are specifically required to be determined by seeing the whole film. So the best argument here, I think, is that even if you were to call the photos duplicates, which again is a very big stretch here, they certainly shouldn't be admissible because the circumstances make it unfair to admit the duplicates there, just the still photos, and that, of course, we see in Rule 1003. Okay, so NSCAT was a California state case, but it was back in 1971, so we need to look at what our current California best evidence code sections say. In California, we refer to this as our secondary evidence rules set forth there in code sections 1520 to 1523. So what I have on this slide is while the wording of the California code sections aren't exactly a copy of the federal rules, they do end up reaching the same result. Actually, the wording in California kind of flips the federal rule, sort of assumes things are admissible unless XYZ. So here's the nutshell version on the slide. Ordinarily, secondary evidence of a writing, recording, or photo is admissible, but secondary evidence can be excluded if the proponent just tries to offer oral testimony about the contents without first providing an excuse for not having provided the original or a copy, right? And secondary evidence can also be excluded when it would be unfair under our code section. So again, we may have different wording, but we reach basically the same result as the federal rules here. Okay, the next case you read, U.S. versus Diaz-Lopez on page 672, that's a Ninth Circuit Court of Appeals case, deals with sort of an interesting issue. What happens when basically what the proponent is trying to prove is that a writing doesn't exist or that a particular contents of a writing doesn't exist. So you remember the facts of the case. Diaz-Lopez here, a Mexican citizen, was accused of being a removed alien found in the United States without permission to return to the United States. So he had been already removed from the country, and now he is found again in the United States. So a Border Patrol agent here in the case testified that he had performed a search of the relevant government database using information identifying Diaz-Lopez, found no record of him having filed the form that would have been required for him to apply for readmission to the country after his earlier removal. And Diaz-Lopez here argued that this testimony by the Border Patrol agent violated the Federal Rule of Evidence 1002 because the government here didn't produce an original printout showing those search results. But as you saw, the court rejected that argument. First, the court does point out, look, yes, databases would be often included in the general definition of a writing and therefore covered by best evidence rules. But the advisory committee notes to Rule 1002 specifically say that the rule does not apply to testimony that books or records have been examined and found not to contain a reference to a particular matter. So the government's evidence here, according to the court, was not regarding contents of a writing. Instead, was really just about the absence of data in this database. It is sort of an interesting case, though, because there really was at least a colorable argument that that a party in fact is proving the content of a document when it demonstrates that the document doesn't contain a given piece of information. The document here being the database, proving that the document doesn't contain that information. But the court said no. The other interesting issue, though, presented in the case, I think, is the concept of, well, what if an error was made either in the filing of the document in the first place in the government database, or in the particular search terms attempted in the case. In this case here, Diaz-Lopez does have that hyphenated name. There may have been issues of a document maybe filed under Diaz when it should have been filed under Lopez, or something, and it's unclear what search was actually done. And you see on page 676, Diaz-Lopez didn't raise his argument. The appellate court points out that this argument wasn't raised about the potential for his form to have been misfiled under a different name, therefore making those particular search terms used very important in the case. But the court did address that possibility and said, by the way, any variation in search terms, that was going to be just about the behavior of the officers here. That could have been an issue for cross-examination, so that also would not have been a best evidence issue. All right, so now we're going to move on to Part B of that writings chapter. Part B of this chapter is about authentication, and that is covered by Rules 901 and 902, so just two rules here. So first, the basic definition of authentication, really this just means making a showing that a thing or a piece of evidence, or even something like testimony about a phone conversation, is what the offering party contends it is. For example, as I have on the slide, is this the gun used in the crime? Is this the letter sent to and received by the plaintiff from the defendant? Was it the plaintiff who answered the phone and engaged in negotiations with the defendant that the defendant now wants to testify about? So starting with Rule 901, 901A uses both the word authenticating and the word identifying in the rules. So those terms are used interchangeably in court sometimes. Sometimes you'll just hear people talk in court about laying a foundation for evidence. So I have on this next slide three of the main reasons authentication is a logical thing to require in court for certain kinds of evidence. Again, often it's tangible evidence like a gun, or documentary evidence like a letter, but it can also be something like a person testifying about a phone call with another person. And there needs to be a showing that the witness testifying knows that the person on the phone was the person he or she is claiming it was. All right, so what kinds of things does authentication accomplish for us? Well, the first thing is to establish the relevance of the evidence, right? After all, a random gun, that's not relevant to a particular criminal case, right? Only a gun that can be shown to have been used in the crime is going to be relevant. So the gun has to be authenticated as the gun used in the crime by presenting evidence that links it some way. The next thing that gets accomplished by authentication, obviously, is showing a piece of evidence is genuine, is authentic. So a great example here, say you have a bag of herb-like substance that may have been found on a defendant. Well, here, the prosecution's going to have to show a good chain of custody, which is going to probably involve the fact that the arresting officer tagged that bag, maybe sealed it in the first place when it was seized. And then additional steps may be described if the substance, say, was tested in a lab, for example. There has to be some assurance for the jury that the bag presented in court, the bag presented by the lab, is the one taken off of the defendant. And lastly, the authentication process serves to place the evidence in the right context, i.e., why is this evidence important in the case? How does it fit in with all the other evidence in the case? It's also, I think, really important to understand what authentication does not do. First, it doesn't guarantee the identity or genuineness of any evidence. It's just a minimum threshold that has to be presented by the offering party, right? But if that minimum threshold is passed over by the other party, the other side always can challenge whether that evidence really is authentic. The defense attorney can challenge whether the gun and evidence can be linked at all to the defendant, or whether it is the one used in the crime, despite the fact that the judge has determined that it was authenticated enough to be admitted in the case. Also, authentication does not guarantee that your evidence is going to be admitted in court. All it does is establish that, well, there's sufficient evidence for someone to find that the evidence is what the proponent says it is. It still has to get past any other possible evidentiary barriers that might be there. For example, in particular, the hearsay rules. So, for example, if there's a document offered for its truth, it consists of out-of-court statements, right? So there has to be an exemption or exception in the hearsay rules to allow that document in, even after it's been authenticated. Okay, so looking back again at Rule 901A, we see that the threshold here is very low. A party doesn't even have to prove by a preponderance of the evidence that, say, a particular document offered in evidence is authentic. Just enough evidence sufficient to support a finding that the item is what the proponent claims it is. So it's easy to predict that this is going to be a 104B determination, right? That makes sense because remember, 104B is called the conditional relevance rule. So if an item of evidence is found by the trier of fact to not be authentic, then it's simply not relevant, shouldn't be taken into consideration. But that's going to be a decision for the fact finder, for the jury. For the judge's part, the judge having to make just that threshold determination, the judge should, as long as some reasonable jury could find the document or object or testimony about the voice on the other end of the phone to be authentic, well, the judge should consider it authenticated. The opponent, of course, like I already said, can offer evidence that it is not authentic, but the item is not going to be kept out as long as this minimal threshold is established, at least for authentication purposes. So, for example, if a witness authenticates a letter by saying that the witness is familiar with the handwriting in the letter, then the letter is going to be authenticated and is going to possibly be admissible. It doesn't matter that the opposing party maybe has on its witness list a handwriting expert or the purported author herself ready to testify, look, this letter is a forgery. The actual authenticity is going to ultimately be a question for the jury to decide. Okay, so again, a pretty liberal standard here. You'd think almost everything is going to be found to be authentic here under 901A, including that fingerprint card evidence in the Dawkins case you read, but sometimes there's suspicion if a court feels like a party just hasn't done enough to cross its T's and dot its I's. So these issues can still arise, especially when something unexpected happens in a case. For example, maybe a new document is mysteriously supposedly found in the middle of a trial. A judge is going to look very carefully at that to see if it's really authenticated. Okay, so Rule 901 and 902 show us the two categories of evidence that need to be authenticated. So the first category requires some type of extrinsic information for authentication. Usually that's going to be testimony by a witness, right, to establish authenticity. And Rule 901B covers this category of evidence, and it lists 10 examples of ways to authenticate some common types of evidence that are going to fall here. But remember, 901B is a non-exclusive list, right? 901B is just a set of illustrations, a set of examples. So a party can authenticate in any way that comports with the general rule in 901A, even if their specific example that requires extrinsic evidence isn't listed directly in 901B. All right, now you saw in reading Rule 902, there's a second category. Second category consists of evidence that in fact doesn't need any extrinsic proof of its identity. So this evidence is considered to be quote unquote self-authenticating. And again, Rule 902 covers those. Rule 902 lists 12 categories of documents that are self-authenticating, and this in contrast to 901B is a comprehensive list. So if a document doesn't fall within one of Rule 902's categories, it is not going to be self-authenticating. It's going to need to be authenticated back under Rule 901. So looking at some of those examples in Rule 901B, let's start with 901B1. 901B1 just makes clear that testimony of a witness who has knowledge about an item, that an item is what it claims to be, will be adequate for authentication. This Rule 901B1 often combines with some of the other examples there in 901B, but putting on a witness with knowledge is the most common way of authentication with extrinsic evidence under Rule 901. Next, in 901B, there's a couple subsections that refer specifically to authenticating handwriting. Obviously, sometimes it's going to be necessary to show that a particular person wrote a document or letter, or a particular person signed something. So, although 901B1 can be used here if the person who wrote or signed the document testifies that the handwriting is his or is hers, or maybe there's a witness who under 901B1, a witness with knowledge, who will testify, look, I saw this particular person write or sign the document. So sometimes 901B1 is a good way to authenticate handwriting. But we also have 901B2, and that allows any lay witness, right? So lay, non-expert witness, who's familiar with someone else's handwriting to identify that handwriting in court. And in order to use this rule subsection, that familiarity with that handwriting, well, that has to have been developed somehow outside the litigation. So it can't be, for example, that the witness here studied examples of someone's writing and is now willing to testify that this particular document has that person's writing. So 901B2, this is usually going to be a family member, a friend, or a coworker, somebody who's familiar with handwriting from personal or work context. And then lastly, we have 901B3, which allows an expert witness to identify handwriting by comparing disputed handwriting on a document to a sample that is verified to have been written by the person in question. And 901B3 also makes clear that the trier of fact, either the judge or the jury, himself or herself, or the jury itself, they themselves can be put to the task of comparing handwriting with known samples of the person in question after those are admitted into evidence. So quite a few ways to authenticate handwriting. Okay, next let's talk about 901B5. 901B5 makes authentication of voices pretty simple. Any witness who is familiar with a person's voice can identify that voice in court, and the witness may develop that familiarity, quote unquote, at any time. So what does that mean? For example, even if a witness who meets a person he spoke with on the phone after that prior phone conversation in question, well, that witness can use his or her later meeting of the person to identify the voice from the earlier call. Okay, so this rule contrasts with 901B3 regarding handwriting identification, because remember, 901B3, familiarity with someone's voice can be acquired solely in connection with litigation or investigation, or prosecution of a case. So 901B5 allows that familiarity to be developed at any time, as opposed to 901B3 that requires handwriting familiarity to be gained outside. Okay? For example, this comes into play a lot with law enforcement officers who listen to voices on wiretaps or who talk to perpetrators on the phone. They're going to be allowed to testify that the person they heard on the wiretap or the person they heard on the phone was the defendant, even if they don't hear the defendant's voice in person until, for example, they arrest the person, or maybe they view or listen to an interrogation that is known to have been that person's voice. Next, phone calls are a really interesting example. 901B6 deals directly with outgoing calls by a witness. So a witness is on the stand, going to talk about an outgoing call that witness placed. So first, 901B6A allows a person to testify about the substance of a phone call to a particular person if they testify that a call was made to the number assigned to that person and there are extra circumstances that indicate that the person who answered the phone, who conversed with the witness on the stand, was actually the person whose number was called. All right, so some courts have allowed testimony here with just a showing that the number assigned to a person was called and that the person answering self-identified, saying, yes, this is Susan, say in a case where the person calling didn't necessarily know or recognize the voice of the person called. But other courts, I have to tell you, other courts have insisted on some additional showing over and above just self-identification. And usually that's just going to be testimony about voice recognition, say under 901B5, or some other identifying information. For example, you can have a call placed to a particular person. Maybe the person said, yes, this is Susan, but maybe if it was a person who hadn't been previously familiar with Susan's voice, you'd want to have something under 901B4 talking about the content of the conversation, the distinctive characteristics of that conversation that also would lead you to believe that it was Susan on the other end of the phone. Okay, 901B6B that I have here on the slide covers outgoing calls to a business, not just an individual person. So there, if you're calling a business, if a call is made to the number assigned to a business, a witness can testify about the business content of that conversation, as long as the conversation related to the kind of business that would normally and reasonably be transacted over the phone with a business like that. The identity of the particular person spoken to isn't necessary when calling a business. All right, so that's outgoing calls. But on the bottom of the slide, I have some comments about incoming calls. We have to be very, very careful here. So courts have unanimously insisted it is not enough for a witness to say, I received a call and the person calling identified as a particular person, and then go ahead and testify about the substance of the call. So here, something aside from self-identification of that caller is going to be required. So nowadays, in the day and age of cell phones, the cell phone will usually tell us what number is calling us. So with a cell phone call, that's something else required might be, well, the call came in from a number assigned to a particular person, plus the person said when I answered the phone, this is Susan, a self-identifying statement. The same, of course, is going to apply to a call coming in from, say, a home phone if the person answering had a reliable caller ID, say, on their phone. That witness would be able to testify, well, I have caller ID on my phone. My caller ID is reliable, and the call came in from this particular number assigned to that person, and the caller self-identified as that person. That's going to be enough to authenticate for that witness to testify about a phone call that he or she received. All right? And of course, if the person answering the phone knows the person who calls him or her, now there could be just testimony about voice recognition to authenticate an incoming call. So several ways to authenticate an incoming call but it's never going to be enough if it's a stranger calling just to say that that person's self-identified. Okay, I want to talk briefly here about the use of chain of custody testimony, because this is going to be very, very common in criminal cases. And a lot of times this is about authentication. So authentication here is going to involve a combination usually of some of the subsections in 901B. Usually 901B1, you've got a witness with knowledge, and 901B4, which we haven't talked about yet. But 901B4 is used with both tangible evidence and with things like phone calls. So authentication can be accomplished by a witness testifying about any of these distinctive features, right? Appearance, contents, substance, internal patterns, any kind of distinctive features there that are listed in 901B4. So sometimes in a criminal case, you have evidence that would otherwise not have distinctive features, like a baggie of white powder, for example. Sometimes that's going to be given a distinctive feature right away by law enforcement, for example, by sealing that white baggie inside another tamper-proof baggie and then tagging it, say, with the date and the time and the location that that baggie was seized and initials of the officer who seized the substance in the first place. But also whether or not something is naturally distinctive or not. Something more naturally distinctive, say, might be a gun or something like that. But whether or not something is naturally distinctive, there is going to be a need always to make a showing that the item is the exact item relevant to the case and that the item hasn't changed or been altered in a way that would affect the case. So sometimes in a criminal case, a prosecutor is going to have to put on multiple witnesses to describe how this item changed hands along the way to complete the chain, right? So every witness in this chain is going to describe what he or she did with the evidence before passing it on, say, to another person or storing it back in a secure location. So maybe a lab technician who tested the baggie of white powder is going to describe receiving the tamper-proof sealed bag with the officer's initials, then opening the bag, removing and immediately testing that powder, and then that witness will describe how he or she resealed the evidence and then what happened to it next. All right, so again, remember, this is just a minimal threshold to get that evidence admitted. And don't forget that a defense attorney can still contest the authenticity of evidence if there is any kind of evidence that there was a break in the chain of custody or maybe a weak link in that chain of custody. Okay, so the last thing I'm going to cover in this video is photos and videos and other visual aids. There just needs to be, with photos, with videos, and other visual aids, just needs to be testimony that the item is a fair and accurate representation of the scene, or fair and accurate representation of the person at the time the photo or video was taken. All right, so the witness testifying here does not have to be the photographer or the videographer who took the photo or the video. It just has to be someone who's familiar with that underlying scene at the time and will just testify, yes, this photograph is a fair representation of what the scene looked like. Okay, this is the end of video 2 on writings.